A single signature on an executive document in Tallahassee weighs less than a gram of ink, yet it instantly froze the operational infrastructure of organizations managing millions of dollars across 50 states. For 24 years, a complex network of public school contracts, university diversity boards, and parallel religious arbitration panels functioned as an unassailable ecosystem within the American legal landscape. It did not expand through sudden, violent shifts, but through the patient, bureaucratic pressure of institutional accommodation. School districts quietly adjusted prayer policies, university administrations modified campus rules after volatile protests. State agencies routinely awarded lucrative social service contracts to non-profits whose parent entities inhabited federal counterterrorism databases. The system was never built to say no, so it negotiated. It looked away until a Republican administration with a legislative supermajority in Florida decided that the decades-long negotiation had ended. What manifested in Tampa is not a standard policy dispute, but the most aggressive state-level dismantle of Islamist institutional influence in modern American history. To understand the mechanics of this sudden freeze, the trajectory must be traced back to a federal courtroom in Dallas in 2007. There, federal prosecutors initiated the largest terrorism financing trial in United States history against the Holy Land Foundation, then the largest Muslim charity in the country. The federal government proved the organization had funneled $12 million directly to Hamas through an intricate web of domestic front groups. The 2008 verdict delivered 108 convictions on every single count. But the critical structural link for Florida's recent legislative action lay in the trial's official list of unindicted co-conspirators. That public list explicitly named the Council on American Islamic Relations, known as CIIR, alongside the Muslim Brotherhood's Palestine Committee. Federal Judge Jorge Solis later ruled that the prosecution possessed ample evidence tying CIR to these specific entities. Following this judicial determination, the FBI quietly severed its long-standing community liaison ties with the organization and never restored them. This foundation extends even deeper into the administrative records of federal surveillance. In October 1993, FBI bugs in a Philadelphia hotel room recorded a multi-day meeting of covert operatives connected to Hamas support networks. The transcribed discussions focused on a precise geopolitical strategy: how to effectively advance the political agenda of the Muslim Brotherhood inside the United States while maintaining the public facade of a legitimate, Western-style civil rights organization. The institutional framework birthed from those taped conversations became the exact Palestine Committee that federal prosecutors cited 15 years later. During the Holy Land Foundation trial, FBI Special Agent Laura Burns testified under oath that CIR operated effectively as a successor organization to the Islamic Association for Palestine, an entity already legally designated as a Hamas support engine. Ghassan Elashi, a key founder of CIR's Texas chapter, received a 65-year federal prison sentence for explicit terrorism financing. Yet, for nearly 2 decades, the broader system absorbed these facts without structural disruption. The organization did not collapse, it expanded. It secured formal invitations to federal policy roundtables, maintained a constant presence as an authoritative civil rights voice in mainstream media, and systematically built relationships within public school boards and state universities. The institutional defense mechanism was simple. Anyone who publicly cited the federal court records was instantly neutralized in polite discourse with the label of Islamophobe. The physical evidence remained fixed in public archives, but the systemic willingness to enforce consequences evaporated. The apparatus adapted to the environment, operating under the assumption that American legal structures would eventually tolerate and integrate the slow cultural drift. Precisely as Western European governments had done over the preceding 30 years, the geopolitical calculus shifted permanently in November 2025. Returning to the White House, President Trump signed Executive Order 14362, mandating an immediate federal review of specific Muslim Brotherhood branches for formal terrorist designations. On January 13, 2026, the Treasury Department's Office of Foreign Assets Control, acting in tandem with the State Department, executed the order. The federal government designated the Egyptian and Jordanian branches of the Muslim Brotherhood as specially designated global terrorists for providing material support to Hamas, while designating the Lebanese branch as a foreign terrorist organization. This federal pivot provided the precise constitutional opening that state governments required. Florida moved first. On December 8, 2025, Governor Ron DeSantis signed Executive Order 25-244, an unprecedented state-level action that designated CAIR and the Muslim Brotherhood as terrorist organizations for state purposes, ordering every agency, municipality, and public university to immediately terminate all contracts, employment, and funding connected to either group. The legal counterattack was instantaneous. Within days, a powerful legal coalition, including the Southern Poverty Law Center and the Muslim Legal Fund of America, filed a sweeping lawsuit in federal court. Their argument targeted the core of executive authority, asserting that a state governor lacks the constitutional power to unilaterally brand a domestic civil rights organization a terrorist entity. They argued that the First Amendment shields organizations regardless of controversial external affiliations, and that due process prevents such sweeping exclusions by mere executive signature. The case landed in the courtroom of U.S. District Judge Mark Walker, an Obama appointee in the Northern District of Florida with a well-documented history of striking down DeSantis administration initiatives. The predicted collision occurred on March 4, 2026. Judge Walker issued a comprehensive preliminary injunction, completely blocking Executive Order 25-244. His written ruling was sharp, stating that the First Amendment bars the executive office from utilizing its authority to make political statements at the expense of established constitutional rights. Instantly, the entire Florida enforcement mechanism was paralyzed. The funding cutoff ceased, the contract terminations were legally suspended, and the organizations declared a definitive victory over what they termed unconstitutional government overreach. For a brief window, it appeared the historical pattern had reasserted itself. A conservative state attempts a bold structural intervention, a federal court strikes it down, and the quiet institutional drift continues unaltered. Except this time, the state of Florida had already built a secondary machine. The secondary machine did not rely on the fragile authority of an executive signature. It was forged from the durable concrete of statutory law. While the federal injunction was being drafted, the Florida legislature was already advancing House Bill 1471, a masterwork of legislative engineering designed by constitutional staff specifically to bypass the First Amendment barriers that had broken the governor's executive order. Passed by overwhelming majorities on March 12, 2026, and signed into law on April 6 on the campus of the University of South Florida in Tampa, the statute bypassed the judiciary by codifying an infrastructure denial regime into plain English. The law did not ban speech or criminalize belief. It severed the financial and administrative arteries that sustained the network's operations. The impact was immediate, systemic, and mathematically calculated to trigger an internal chain reaction across the state's institutional landscape. The first failure mechanism struck the financial foundations of the advocacy network through a total prohibition on the domestic applicatio of foreign and religious law. Under HB 1471, no Florida court, administrative body, or arbitration panel can enforce any contract, choice of law clause, or family dispute resolution that incorporates Sharia principles if they conflict with state constitutional protections. This single provision instantly destabilized the business model of parallel judicial bodies, such as the Dallas-based Islamic Tribunal, which had begun expanding its mediation footprint into Florida's wealthy coastal counties. By rendering these parallel rulings legally void and creating direct civil liability for tribunals falsely claiming judicial authority, the law triggered an immediate freeze in private capital allocations. Wealthy international donors and domestic corporate networks realized that their structured agreements were suddenly unenforceable in the third largest economy in the United States, causing an immediate withdrawal of institutional capital. The second link in the chain reaction tore through the state's education infrastructure, converting academic funding into an ideological landmine. The statute completely strips private schools affiliated with designated groups of their access to Florida's massive taxpayer-funded voucher program. Simultaneously, it bars public universities from utilizing state or federal funds to maintain programs, event venues, or student groups tied to designated entities. The immediate operational consequence was chaotic. At the University of South Florida and Florida Atlantic University, university compliance officers, terrified of losing hundreds of millions in state appropriations, began preemptively cancelling student organization charters and freezing bank accounts. Students who actively promoted these designated groups suddenly found themselves ineligible for tuition fee waivers, institutional scholarships, and public funding. Face to face with immediate administrative expulsion, this educational freeze instantly triggered an economic crisis for the advocacy organizations themselves. The loss of university lecture circuits, diversity training contracts, and school board consulting fees erased up to 40% of the predictable operating revenue for regional chapters within 48 hours. To compound the disaster, a companion bill, HB 1473, placed all evidence used by the Florida Department of Law Enforcement's Chief of Domestic Security to designate these groups behind a permanent public records exemption. When the legal coalition attempted to mount a defense, they found themselves completely blind. They could not subpoena the state's investigative files, meaning they could not see the specific financial transactions or federal surveillance links being used to destroy their legal status, rendering a traditional due process defense practically impossible to construct. The attempts to stabilize the system only accelerated its collapse. In a desperate bid to maintain institutional relevance, national directors ordered regional offices to aggressively litigate, launching a massive public relations campaign funded by out-of-state donors. But this defensive maneuver backfired. Under the new statute, any corporation or non-profit providing material support or resources to a designated domestic terrorist organization faces immediate administrative dissolution by the Florida Department of State. The moment the law firm of Aquil and Valentine and the Southern Poverty Law Center moved to funnel defensive funds through interconnected non-profit shells, corporate compliance departments at major American banks, including JPMorgan Chase and Wells Fargo, panicked. To insulate themselves from felony exposure and potential state-level vaporization, the banks began systematically offboarding the accounts of not just CIR, but every interconnected civil rights coalition, charity, and legal defense fund under investigation. By June 2026, the contagion had escaped Florida's borders, mutating from a localized legislative strike into a multi-state systemic shockwave. Texas Attorney General Ken Paxton utilized the Florida template to launch an aggressive enforcement drive, issuing sweeping document demands to Texas-based tribunals and instantly excluding Islamic academies from the state's multi-billion-dollar school choice voucher system. The Foundation for Defense of Democracies simultaneously published a comprehensive legislative blueprint, providing 44 other state legislatures with the exact statutory phrasing required to replicate the Florida model without relying on vulnerable executive actions. The entire landscape of the American South shifted overnight. What had been a highly successful 20-year strategy of quiet institutional penetration was transformed into an active legal and financial liability for anyone associated with it. The point of no return arrived silently in late May as the July effective date approached. The system did not experience a loud, definitive collapse. Instead, it underwent a total institutional evacuation. The Florida Department of Law Enforcement finalized its first official designation list, explicitly pairing Islamist networks with transnational criminal organizations like Tren de Aragua and militant groups like Antifa under the same domestic terror classification. University boards of trustees, faced with the total loss of public funding, began rewriting campus charters to ban all forms of parallel institutional lobbying, while regional directors quietly signed non-disclosure agreements and began liquidating physical assets before the state could seize them. The infrastructure built over 2 decades to absorb and tolerate the slow, patient drift did not bend. It simply snapped, leaving the entire national network standing on the absolute precipice of structural erasure. The permanent reality taking shape across the American landscape is no longer a matter of legislative debate. It is an unyielding calculation of institutional survival. As the July 1 effective date approaches, the strategic infrastructure built by advocacy networks over 2 decades is undergoing a forced structural liquidation. The political calculation that American institutions would indefinitely absorb parallel legal and cultural systems has collapsed under the weight of statutory law. What remains is not a temporary vacancy, but a completely rewritten legal standard where the state holds the absolute power to choose which entities are allowed to interface with public commerce, education, and governance. The slow drift toward institutional capitulation has been violently reversed, creating an entirely new category of systemic risks that stretch far beyond the borders of Florida. The immediate economic consequence of this shift is the wholesale extraction of targeted organizations from public and private supply chains. Nonprofit entities that once drew steady revenue from state social service grants, municipal outreach initiatives, and public university partnerships are finding their accounts permanently frozen as major banks rush to insulate themselves from potential felony exposure. The price of this total exclusion is paid not just by the leadership of these groups, but by the community networks that relied on their legal, social, and educational services. Private Islamic schools, suddenly severed from Florida's massive voucher funding apparatus, face immediate budgetary insolvencies, forcing emergency consolidations or outright closures. The administrative mechanism does not pause to negotiate. It enforces an immediate digital denial of resources. This domestic purge has triggered an immediate destabilizing geopolitical reaction across international diplomatic networks. Several Middle Eastern sovereign wealth funds and non-governmental organizations, which had historically anchored large endowments within American academic institutions, have begun quietly reallocating capital away from states advancing this legislative model. Foreign ministries in Doha, Ankara, and Amman are watching the unprecedented expansion of state-level national security powers with growing alarm, realizing that domestic legal protections can now be dismantled by a state legislature. The traditional federal monopoly on foreign affairs has been disrupted. An individual state government has demonstrated it can effectively execute independent foreign policy objectives. By shutting down domestic entities linked to international movements, the countermeasures launched by civil liberties groups and legal coalitions are revealing themselves as entirely insufficient and delayed. The traditional strategy of securing a swift federal injunction based on First Amendment protections fails when the state shifts the battleground from executive overreach to statutory public safety mandates. While the Southern Poverty Law Center and CI assemble massive constitutional challenges, the litigation is projected to grind through federal appellate circuits for years. In the interim, the law remains live, active, and fully operational. A business, university, or municipal board cannot afford to wait years for a Supreme Court ruling while facing immediate state funding termination or administrative dissolution. Institutional compliance departments are choosing self-preservation over ideological solidarity, executing a total purging of affiliations before the state can issue a formal designation. Charity and security network the victory is being aggressively seized by a new generation of conservative politicians who recognize that institutional warfare is the ultimate path to political advancement. In the brewing 2026 Republican gubernatorial primary, candidates are already weaponizing the Florida template to prove their willingness to deploy the raw power of the state against perceived internal adversaries. This political dynamic guarantees the rapid proliferation of the model. What began as a targeted strike in Tallahassee is being copied word for word in state houses across 44 states. The strategy is clear. State-level authority is being structurally hardened to create permanent, parallel national security apparatuses that operate completely independent of the shifting political priorities in Washington. This fragmentation creates a profound and dangerous systemic risk for the American constitutional order. By establishing independent state-level terrorist designation processes shielded by permanent public records, exemptions, states are building an opaque, weaponizable machinery that can easily be pointed in the opposite direction. The long-term trajectory points toward an irreconcilable balkanization of American law. where an organization recognized as a legitimate civil rights champion in New York or California is branded a felony criminal enterprise the moment its personnel cross the state line into Florida or Texas. The unified national legal framework is fracturing, and the mechanisms designed to maintain institutional cohesion are actively driving the separation. There's no path back to the quiet accommodations of the past 2 decades. The assumption that the American system would inevitably bend the way European institutions bent has been permanently shattered by the boring, durable mechanics of representative legislation. The infrastructure denial regime is live, its teeth are sunk deep into the institutional landscape, and the state has proven that it will no longer look the other way.